Kia Commissioner Shepherd. At the moment, we don't have McFarlane Agriculture here, but we do have John Talbot on behalf of Bowden Environmental, and we've got Victoria.
Yes, I can see Mr. Talbot's there. Thank you for coming, Mr. Talbot. We should just give Mr. McFarlane a few minutes grace in case he's just been held up and will be coming in a minute or two. If you get a message from him, possibly this is him now, is it?
No, that's not a it's not Mr. McFarlane, no.
All right, well, we'll just be patient for a minute or two more, if Mr. McFarlane doesn't come in a minute or two, then we'll see whether Mr. Talbot is willing to have an earlier start than he was entitled to expect. Well, since Mr. McFarlane isn't with us at the moment, I'm wondering, Mr. Talbot, whether you would be inclined to come and start a bit earlier than you've been given the notice for. So that we're now coming to the submission by Bowden Environmental. So good afternoon, Mr. Talbot. Thank you very much for coming, and thank you for fitting in a bit earlier than you'd been given to expect. We have the submission, and we have your statement of evidence, and we have an addendum to that. And we have, of course, read what you've sent us, but that's not to preclude you from taking whatever you got, whatever course you would like in how you present the submission to us.
Thank you, Mr. Chairman. Is volume all right? Hopefully
Excellent.
It is.
Thank
Good.
you.
I certainly won't read the evidence, Mr. Chairman. I'll just summarise, and it'll be a reasonably brief summary. I hope what I've written is reasonably readable, and we've been here before, of course, with some of these aspects. perhaps I might get through this time. I just want to highlight 4 points. In the table I attached to the written evidence, there are just 2 points I want to highlight there.
Thank you.
I want to summarise the groundwater allocation issue and then summarise the surface water issues for just 2 streams, the Cam River and the Cust River. I want to start with the groundwater allocation issue since it's the first item on my written evidence.
Yes, please. It's a very important issue.
I think the overall summary about groundwater allocation is that what appears in the Land and Water Regional Plan now and what was in the previous plan, the Natural Resources Regional Plan that the CLWRP replaced, were limits to groundwater allocation based on groundwater zones, which were an artificial construct. And the limits, the allocation limits for each of those artificially constructed zones are certainly not what you would classify as sustainable limits or limits beyond which unacceptable adverse effects occur. And that was clearly stated in a previous plan, and they do not meet, in my view, the test in the RMA of sustainable management. The reason for identifying a limit nearly 20 years ago now, it's making me feel a bit old, was because there were concerns that in some of those so-called groundwater zones, which are just an artificial construct of a sizable area, was simply to identify in an area or a zone whether or not allocation was high or low and what was the trend in that allocation. And if the allocation was high and increasing, then perhaps there was a need to look at it more carefully. And that's the way the system was set up nearly 20 years ago in the Natural Resources Regional Plan. And to allow more care to be taken to look at those allocations, the rules provided that additional allocation over and above that limit was classified as non-complying, rather than prohibited as it is at the moment in the Land and Water Regional Plan. And a number of people, applicants, took advantage of that, of course, and were able to convince hearing panels through quite large hearings, I must say, a lot of information provided, to be able to grant additional groundwater allocation over and above those limits that were called adaptive management consents. In other words, if groundwater levels were high at the start of an irrigation season, then additional water could be taken. If they were low, then no water could be taken. And that's the way it was set up originally. So they were called interim limits back then. Unfortunately, it seems as though those allocation limits, the more people have talked about them, the more they seem to be cemented in people's minds as though they are a sustainable limit. They're based on sustainability principles, when they're not. This is another opportunity to raise this issue, and hopefully my written material clearly identifies how those limits were calculated and what they actually mean. This is another opportunity to perhaps put it right, in my view, and allow for those areas where that interim, I'll keep calling it interim because that's the way it was classified in my mind nearly 20 years ago, that would allow people to apply for additional water as a non-compliant activity and to provide enough technical information to convince a hearing panel that water could be taken above certain trigger levels in the groundwater system, as an example of how it could be done. Of course, at the moment, and continuing in Plan Change 7 for the Waimakariri area, the allocation limits are still classified as definitive, and taking above that is prohibited, so nobody can apply. Although I would say there are some allocations that can be applied for. Of course, permitted activities can continue, but community water supplies can also be taken over above that limit. They are not part of the prohibited activity status, which is a bit curious to me, that a community water supply that has not just domestic and those sort of needs, but also industrial and commercial that are supplied by a district council or city council water supply, can still take above that limit, but if you're not part of a community water supply, you can't. Seems a bit contradictory to me. So my submission is that above those so-called interim allocation limits, instead of prohibited activity, should be non-compliant activity with the usual tests that are required for a non-compliant activity. And those tests are already in the plans. And I've set those out earlier in my evidence as well about the principles that must be guarded against. Plan Change 7, unfortunately for the Waimakariri area, doesn't even rely on those so-called interim limits. It's trying to reduce them even further without any scientific basis that I can see, to be the current allocation plus 10%, or the current allocation for one zone, which is so-called over-allocated. So even further from any scientific basis in my view. So I believe those interim limits should be retained, and there should be non-compliant activities to apply for water above it. There is a bit of discussion in the Section 42A reports and Section 32 reports and so on about allocation increasing up to the allocation limit. Well, that just won't happen in my view. Most years, the allocation or the actual taking of water will only be between 40 and 60% of the allocation that's been granted for a particular consent, because the allocation on a consent is based on meeting needs for a farming activity irrigation in 9 out of 10 years, a very dry year, not the more normal sort of years we get most years. There was also discussion about what's happening to the groundwater in the zones, and the only way to assess that is to look at long-term groundwater level records, which has been done to some extent. But I don't see any long-term continuing decline in groundwater levels throughout the Waimakariri Plains. And I've provided some information about 2 wells with long-term records that were in the Section 32 report, and simply I do not see any long-term continuing decline. There is no allocation or abstraction above any sustainable level. Looked at 2 surface water resources now. The 2 rivers that I want to look at are the Cam River and the Cust River. First of all, for the Cam River, a small spring-fed stream in the lower plains. Its current minimum flow is 1,000 litres per second at its measuring point. And as is probably fairly well understood now, and was even back in the early 2000s when that minimum flow was established in what is currently the Waimakariri River Regional Plan, which has been replaced by Plan Change 7, it was understood that that level of minimum flow was higher than what would otherwise be required for in-stream needs, solely to satisfy dilution from the Rangiora Township's sewage discharge. That discharge has long been taken out of the river, of course, and the Waimakariri District Council operates an ocean outfall now. But it seems as though the science of what the minimum flow should be based on in-stream needs has not been applied for this particular river, the Cam River, has been applied in all the other cases, all the other spring-fed streams and rivers, but not in this case. So my submission is that the science should be relied on, as it has been in all the other rivers, and that the minimum flow should be 890 litres per second, not the 1,000. And there are some technical reports, science reports, that the council has to justify that number. For the Cust River, there is for the upstream, or the Cust River it's called, the Cust changes its name to Cust Main Drain halfway down for reasons because it was known as a drain in its lower reaches, pretty well man-made really to drain the lower plains area. The Cust River is the upstream half. The Cust River minimum flow is being increased from 20 litres per second to 60. There's no issue with that. However, there is a capping of allocation to current consent numbers or allocations. Now, I've got no issue with that either. I think all these lower plains spring-fed streams would be under stress if allocations were larger than what's been abstracted now, and in some cases it should be reduced anyway. However, what I do have an issue with for the Cust River specifically is that by capping the allocation and increasing the minimum flow, which I don't have any issue with either of those, it's going to put a lot of pressure on those irrigators who rely on the Cust River. And one way to alleviate that is to provide for the opportunity for pumping into storage when river levels are very high. And in fact, there are some farmers who are building storages now for that particular purpose. These rivers flow at very high levels during the winter when it rains on the plains, and my addendum to my evidence, which you mentioned, Mr. Chairman, is of the Cust, showing photographs of the Cust River during the winter, during some years when river levels are very high. And in fact, the Cust River just cannot cope with the rainfall, and areas get significantly flooded, as shown in those photographs. That is the occasion or the time that I believe there could be an opportunity to take a reasonably good chunk of water to pump into storage or storages. In those photographs, the flows are well above 20 cumecs, and in one case, from the records that ECAN has provided, it's up around 50 cumecs, very large flows. That could be an opportunity to provide for what I've called a C allocation of, say, a cumec, to allow farmers to pump into storage at quite high rates, up to a cumec perhaps being provided, to alleviate the higher minimum flow during summer times. third issue that I want to, they are the two issues related to the surface water flows, the CAM and the CUST. I'd like to now just turn to the table in my evidence, and there were just two matters I want to highlight from this table. I think everything else is pretty self-explanatory in the table, but I just want to highlight this. And the first issue is actually on page 10, which is the first row in the table. Policy.
Is this in main evidence, Mr. Talbot, or in the addendum?
No, it's in main evidence, Mr. Chairman.
So page 10.
It should be a table.
Yes,
yes.
Correct.
So the first,
Thank you, I did that.
yep, the first row is related to policy 4.6.
Yes, I'm right with you, yes.
Yep. And there is a definition of stock water. It's probably not quite clear enough, or could be made clearer, and I believe could be widened to cater for things like animal welfare needs, dairy shed washdown water, as well as stock drinking water. At the moment, the interpretation is from Environment Canterbury is that stock water means stock drinking water only. And anything over and above that, for example, for dairy shed washdown or other animal welfare issues, requires a consent, and if it's a take from a stream, for example, it has minimum flow conditions. So there will be occasions during the summer when no water could be taken for those quite essential needs for animal welfare or dairy shed washdown. Those needs are very small. And I don't believe they would cause any problems if they were included in that definition, and then the appropriate rule, of course, so that they were exempt from minimum flow provisions. The second issue I wanted to highlight in the table is near the end of it. It's on page 17. And while there are a number of matters there, the only one I want to raise for clarity purposes is at the bottom of that page, in relation to table 8.2. Table 8.2 sets out the regimes for each river and stream with minimum flows, allocation limits and so on. And on the bottom right hand of that page 17, I talk about the Eyre River.
Yes.
And the Eyre River, it's a floodway really. It's dry for 50 weeks a year, flows a couple of weeks a year, usually on average, because of heavy rainfall. It is a way of getting rid of floodwaters, stormwater runoff and so on. And down the bottom end there's a diversion into the Waimakere River rather than where it used to flow into Kaiapoi. And that diversion was put in place many decades ago. The Eyre River is actually included in that table 8.2, but there's no allocation allowance. Now it's not clear whether that means no water can be taken or whether the Eyre River just isn't part of the regime, or the regimes that restrict or otherwise water from the Eyre River. Now the reason I say that is because there is another river in that table that is set out exactly the same way, and that's for the Kairaki-Macintosh River. And the Kairaki-Macintosh River, certainly there was no allocation available. That was the intent. But is that the intent for the Eyre River? It's not clear because it's set out with exactly the same wording. Either there has to be an explanation or the Eyre River line removed from the table. Now, I'm not too worried about takes from the Eyre River directly because there are none, there is no water there. It's the shallow wells next to the river that are stream depleting wells. And stream depleting wells next to shallow wells next to a river are included in the river regime, minimum flow regime and restriction regime. There are a lot of shallow wells along this Eyre River zone, and it's not clear whether they are part of this line in the table that there's no allocation available from. So that ambiguity, I think, needs to be cleared up. Now, the only other issue I want to raise, which is general to all the allocations, is that the allocation limits, both for the rivers and streams and groundwater, in some cases, or for all the streams anyway, are capped at what are called the existing consented allocation. Now that's fine, I don't have a problem with that. But my experience is that the numbers, those numbers that have been listed, certainly are not an additional summation of the actual allocations when you add up all the consent or the numbers on the consents. It's my experience that there are lots of errors in those numbers. And to make it a prohibited activity to take above those limits when those numbers might be in error could be either bad for a prospective abstractor or bad for the river itself. The numbers need to be correct, and I don't know how that can be achieved without a very careful scrutiny of how those numbers were derived at, looking at big lists of consents, which is what we do. As you know, I work for a small consultancy and we do this because we always find errors in ECAN's numbers. And I think you've been provided with information recently for a groundwater zone down in the Levels Plains area, which identifies this problem. It's not just there, it's everywhere. And I think perhaps the only way to get around it is to provide some sort of wording that says it's the actual consented allocation as of a certain date, or the number in the table if that's not going to be corrected or maybe being updated. But it's the actual consented allocation in words, which means that people like me can check. We've had situations where a client asks ECAN if there is any allocation available from a zone, a river or a groundwater zone, and they're told no, there isn't, it's fully allocated or over-allocated. Only to come to us and we do the summing up and we find that water is available. Now, people who have been told there's none, and then somebody else comes along later and finds that there is because we've done the job for ECAN that ECAN should have been doing. There's one or two frustrated people out there and probably quite angry. There is a way to get around that issue, and I think using the words I've suggested would do that. Thank you, Mr. Chairman. That summarises really everything I need to say.
But as always, it's valuable to have your experience and going back decades as a background to what you are presenting now. I'm going to see if Commissioner Van Voorthuizen has any questions for Mr. Talbot first.
Yes, thank you. Mr. Talbot, in your evidence, and you've spoken a lot about Table 8-2, which involves the cust in the Eyre River. In your evidence, you suggested that the allocation limit for A permits for the Cust River should either be 366 or 394 as opposed to 290. You didn't emphasise that in your verbal presentation. Is that still your concern?
It's the concern related to the last aspect.
Yeah.
Those numbers aren't my numbers.
Right.
They are ECAN's numbers. You'll
Yeah.
find various numbers in various documents, which just highlights the problem that I've just raised with you.
Okay. So it's still an issue for you. So in terms of Table 8-2, no questions for you because the points you've made are clear. But for the officers, so in reply, can you specifically address a number of matters relating to Table 8-2? The first is whether or not the minimum flow for the Cam River at the Ruataniwha or the Youngs Road minimum flow site should be 890 as suggested by Mr Talbot, or if it should remain at 1,000, and can you specifically address the matters he raised in his evidence in that regard? Also come back to us on whether or not it is appropriate to have a C block for the Cust River if that is only enabling high flow takes to go to storage, which we would call water harvesting in other parts of the country, which generally is seen as a good thing. Can you specifically address the issue raised regarding stream depleting groundwater takes for the Eye River, which I think I'd like to see staff comment further on that. And then that final issue, the allocation block for the Cust River, the number of 290 based on the resource consent inventory, is that the right number or is there a different number that's more appropriate? So if you come back to us on those issues, I'd appreciate that. And then, Mr Talbot, just a couple of questions for you. I think in other hearings, and you spoke early on in your presentation about the adaptive management groundwater take consents based on levels. And I recall we've had evidence from, and I can't remember who, that those consents are now viewed as very complicated and difficult to implement and monitor compliance with. And so they, my understanding or recollection is that that approach is no longer in favour. Do you have a comment on that in terms of the complexity of those consents?
I don't think they're complex, really. They're analogous to a surface water take. A surface water take has a minimum flow at which no abstraction can be taken, and above that minimum flow, a certain proportion can be taken up to another number, and from there the whole of the consent can be taken. For groundwater takes, for the so-called adaptive management, and adaptive management is one way to address this issue. Adaptive management is very similar to that. Each year, at the start of each year, in September, groundwater levels are monitored in various trigger wells, and if levels are above a certain level, in other words, the groundwater resource is healthy, there's a lot of water there, it's been good winter recharge, then the total of that consent can be taken. If it's at a low level, and that low level is defined in the consent, then no water can be taken, or a very small amount. In between that, a proportion. So it's very similar to a surface water take. To me, it is not complicated, because the only thing you have to do each year is measure one groundwater level at the start of September, and that dictates how much water can be taken for that season. It's simpler, much more simple than surface water takes, where the river flows are monitored continuously, and every day, as water levels in rivers go up or down, different rates of water can be taken from each consent. So for the adaptive management consents for groundwater, it's very simple, I think.
The second question relates to the issue you raised about stock water, and you specifically referred to dairy shed washdown water and animal welfare. Now, a similar issue arose in the Waikato in terms of variation 6 to their regional plan, which is water allocation variation, and the issue of dairy shed discharges arose there, and it was seen as a significant issue because of the number of them and the volume of water used. It wasn't seen as a minor issue at all. Do you have any idea of the types of volumes would be involved with the sort of change that you're suggesting to us? How many dairy sheds, how much water they use each day? What's the cumulative impact of that? Has anyone given that any analysis?
Well, we apply for consents on behalf of clients for stock water drinking and dairy shed washdown purposes, and they're usually lumped together because they happen every day. And for a decent-sized dairy farm, 100 cubic metres a day. Now, that's taken at a rate of about 1 litre per second. Very little water, really, but a very essential need. So the rates and volumes are very small, but at the moment, unless it's stopped drinking, the other aspects are restricted by minimum flows or other restrictions. And it seems to me, for very little effect, for a very essential purpose, I don't think they should be restricted.
In terms of cumulative impacts, how many of these dairy sheds would be affected by this change? Is it tens or hundreds or thousands?
No, it's a good question. I can't tell you that, unfortunately. A lot of them are groundwater takes, but these are the ones that are specifically the surface water takes I'm raising. I would say the vast majority are groundwater takes, but there are some areas where groundwater is quite limited in availability, so surface waters are used for stock drinking and dairy shed washdown purposes. I would say it'd be a lot less than half the dairy sheds.
All right, thank you.
Commissioner Solomon, any questions for Mr. Talbot?
Yes, I just have a couple. Thank you for your helpful explanation about groundwater and surface water allocation and how it's been managed so far. In your introduction, you mentioned what your role at ECAN was as a senior officer in planning, regulatory and scientific fields, so you may know the answer to this. At paragraph 8, page 8, paragraph 27, the last sentence, you mentioned allocation limits. My question is, why are allocation limits set at the sum of resource consent allocations rather than the needs of a river ecosystem, when the purpose of the Act is about sustainable management, which includes safeguarding the life-supporting capacity of air, water, soil and ecosystems?
That's a very good question. For the Waimakariri area, which is the submission I've lodged in PC7, the allocation limits that are currently in place in most cases are more than what's currently consented. Now, those limits, allocation limits, were set actually 25 years ago. Now, that may not be appropriate, and I don't think it is appropriate for these small spring-fed streams, which is the ones we're talking about, Cam, Cust, Northbrook, Southbrook, all these. They are very limited in how much water can be provided and still maintain the healthy ecosystem, as you quite rightly point out. So in most cases, if the allocation limit was reduced to what is currently consented, that would be quite a large reduction in how much water is being allocated. I've got no problem with that. I think those allocations should be reduced. But on the other hand, we've got a number of consent holders, farmers, who are relying on that water for irrigation and other things. So there's a weighing up of those two aspects. But certainly the minimum flow, the minimum flows are essential, and they are pretty much the same as what's in the current plan. The science has backed that up again, and the allocation limits are being reduced quite a lot for a lot of those streams, which I agree with.
Thank you. My last question is, because you were an staff at ECAN, what criteria do council use to define drains?
Drains.
Yeah. Because I know of some rivers that are also defined as drains.
Yeah. it's probably a misnomer for a lot of these now rivers. I would say what we call the Cust Main Drain, I would say it's a river. But the name Cust Main Drain was established many decades ago, before we were even here. And it's just a name that's stuck. But I would classify that as a river now. I would classify a drain as something that's artificial, something that has been man-made, dug for reasons of drainage, usually land surface drainage, runoff, that sort of thing. That's what I would classify a drain in the normal sense of the word. But I would say out in the Waimakariri Plains now, even though they were dug for those purposes, even number 7 drain, all the herringbone systems set up on the Cust Main Drain, I would say they are now streams. I wouldn't classify them as drains anymore.
All good, David.
All right. Mr. Talbot, a fairly broad question that I could ask of you because of your extensive experience in this region. When we're thinking of surface water, we never think of allocating everything that's in the river. We have long been accustomed to the idea that we had minimum flows to make sure that the needs of the river and its life are looked after. And we use phrases like ecological health and so forth for that purpose. When we're thinking about groundwater, I don't seem to hear so much of an emphasis on the limits of the amount of groundwater that might be taken beyond just pumping until it runs dry and then drilling down further. Is there a proper provision in terms of the purpose of the Act in respect of limits to the amount of groundwater that can be taken?
I think so, and I would call that a sustainable limit, and I'd describe it like this. First of all, the amount of groundwater in the plains and the gravels in the plains is extensive. The gravels, the aquifers, extend several hundred metres deep in most areas. In some areas the aquifers are quite thin, might be only a few tens of metres thick. Those gravels are saturated, they're full of groundwater. Nobody would seriously suggest that we pump until those gravels are dry. That would be mining of the groundwater. The groundwater levels would be continuously declining from year to year to year. That is unsustainable groundwater abstraction. So the question is, what is sustainable groundwater abstraction? And you can look at that from several different aspects. One is only allocate a proportion of how much water enters the system each year, groundwater recharge as we call it. And groundwater recharge comes from seepage out of rivers, rainfall, that sort of thing. And in fact, that's how the so-called interim groundwater limits were established. A proportion or 50% of the average rainfall or half the recharge was the number that we used to come up with those allocation limits. So that's one way, restricting the total allocation to half of what is going into the system each year, or the average of it. That's very crude, a very crude system, because you cannot guarantee that those principles of groundwater, sustainable groundwater allocation are met, and they're set out in paragraph 7 of my evidence. There are 3 principles, and they are set in the plans at the moment, and they have been for quite some time. There are 3 principles. One is there's no continuing decline. in long-term groundwater levels. Secondly, that if there are any streams, spring-fed streams that rely on springs or being fed from groundwater, they aren't reduced in flow to undesirable low levels. And thirdly, looking at the flow of groundwater beneath the land out to sea, which is where all water ends up in the end, that the groundwater-freshwater interface doesn't migrate under the land. They are the three principles to use to establish sustainable groundwater abstraction. The best one to look at is groundwater levels, and that's the trigger level aspect that I've been talking about. That's what the adaptive management consents utilise in a way, is to look at groundwater levels. If groundwater levels are high, because we've had recharge each year, good winter recharge each year from rainfall, then more water can be abstracted. If groundwater levels are low, and you have to decide how low you want to go, if groundwater levels are low, then less, or in some cases no groundwater could be abstracted that year. That's the way to assess sustainability of groundwater abstraction. To date, there hasn't been that sort of assessment. It was set up 20 years ago when the so-called interim groundwater limits were set, that within 10 years, the first review of that plan, certainly not 20 years later, that within 10 years, better sustainable groundwater abstraction limits would be identified. Nothing's been done to date. That disturbs me at no end, to be honest. I'm a groundwater engineer by training. So that disturbs me that that hasn't been looked at and done properly. Hopefully that's might be a long answer, but that's the way I would assess sustainable groundwater abstraction.
Well, not a long answer, it's a helpful answer, but there's one further step that I'm a bit unclear about, and this is an additional matter on top of the matters that you've referred to in paragraph 7. With surface water, we're concerned with the natural life of the river itself, the ecological, whatever the right word is. Now, some of the evidence that before talks about the stygofauna in the groundwater, and this seems to be talking about life, natural life that exists in the groundwater. And should there be an equivalent contribution to the limits on taking groundwater in terms of the natural life that exists in the groundwater?
Yes, I'm aware of little greeblies and things that live in the Vado zone, the area that sort of gets saturated and unsaturated as groundwater levels rise and decline, and other things that live in the water. I've not looked at that aspect specifically, but I would say that if the groundwater levels are maintained at a high enough level so that those three things that I've identified in my paragraph 7 are maintained, particularly the middle one, that the spring-fed streams don't dry up. I mean, springs are fed, are groundwater fed. So long as the spring-fed streams don't dry up or get too low that it's undesirable low flows, then I would say we've maintained a fairly healthy groundwater system as well.
But it's not one that has the consideration also of the life, the natural life of that water.
I've not seen any assessment of that, no, not to date. And I certainly haven't done that sort of assessment myself either.
Well, Mr. Talbot, as always, we're very grateful that you persist in coming in to give us further information.
God loves a try it.
It's an assistance to us to understand the background to a lot of what is before us now. So many thanks indeed for the trouble you've taken and for coming in today.
Thank you, Mr. Chairman. Thank you, Commissioners.
Now, which is the next submission for us to consider this afternoon, please?
We have Victoria Caseley here.
Splendid. Good afternoon, Ms. Caseley. Thank you very much for coming in. We have your submission before us, and you've taken the trouble to write out very clearly and easily for us the matters that you were wanting to raise. So now, would you like to speak to them?
Yes, thank you very much. Firstly, I must draw your attention to paragraph 1.2 of my evidence. I am employed as a national planner for Ravensdown in their environmental team. I wish to make it clear that I'm not appearing on their behalf in any form today. I'm appearing in front of you as myself, on behalf of myself, my husband, as a farmer and landowner in the Waimakariri district. I did debate about presenting evidence today, but I'm hopeful that I am able to provide some assistance to the panel in my experiences, my practical experiences as a landowner, in light of my background. I do wish to advise that my written evidence does require some amendment arising from the National Policy Statement for Freshwater Management 2020 and the Resource Management Stock Exclusion Regulations 2020 coming into force. In particular, paragraph 4.4 is no longer applicable, and I wish that to be struck from the record. The regulations, in essence, have made farmed cattle, deer and pigs in rivers and lakes prohibited in certain circumstances, and to that effect that aligns with the proposed rules in proposed Plan Change 7. I also accept that the chasm I've referred to in paragraph 5.1 has reduced somewhat in quantum given the regulations.
Just a moment, if you would please, that I get to that. So what amendment do you wish to make to 5.1? Or do you just wish to make a remark?
I just wish it to note that the chasm I refer to there and the way I've referred to it sounds rather large. That is no longer the case. The two provisions have come somewhat closer together since I wrote this evidence.
Very well.
And I just have some comments to make about paragraph 5.3, where originally I was asking for the status with the stock exclusion within the Waimakariri sub-region to change, or there was the exclusion of ephemeral streams in line with the proposed NES. That's altered slightly in terms of the regulations for the following reasons. In my opinion, I consider that the Resource Management Stock Exclusion Regulations 2020 give effect to the National Policy Statement for Freshwater Management 2020. And to that extent, they are a more current and applicable document in relation to stock exclusion. I also believe that the regulations themselves provide certainty and clarity for stock owners, and if that was followed by proposed Plan Change 7, stock owners are no longer working to two separate and potentially conflicting provisions. I also consider that the stock exclusion regulations provide a reasonable time frame for works to be completed. To this end, there are a number of landowners in a similar position, such as myself, where I describe myself as a night and weekend farmer. And the implications, both in terms of time and money, mean that it's difficult to do the work in a fairly compact time frame. That is not to say that people such as myself are not already working towards stock exclusion. I also consider that by giving effect to the stock exclusion regulations as opposed to the rules that are currently in proposed Plan Change 7, it would allow for a more detailed assessment to take place to determine where more stringent conditions would be applicable, as opposed to the current blanket prohibition that does not, in my opinion, actually relate to individual local circumstances and therefore could be considered inconsistent with the principles of Te Mana o Te Wai. And finally, I think that it would confirm beyond any doubt, given the MFE guidelines, that femoral waterways are exempt. And my personal opinion is that is necessary because whilst I do understand from case law and the definitions of rivers and interpretation, the interpretation at ECAN amongst their staff is mixed, and from time to time we are regularly informed that a waterway that is femoral is required to be fenced and stock excluded. So to my mind, that needs to be clearly clarified. That's all I wish to make a comment on, subject to answering any questions that the panel may have of me.
Well, thank you very much. Thank you for the thought and preparation you've given to this, and particularly your statement of evidence. Commissioner Solomon, do you have any questions to ask of Ms. Caseley?
Yes, thank you. Did you bring any photos that I could have a look at these gullies that are apparently ephemeral streams?
That's a really good point. No, I didn't. I can provide some if that would be of assistance.
That would be really helpful, thank you. And the only other comment I want to make, yesterday we had Council for Environment Canterbury, and I'm just referring to your concerns over a definition for wetlands. Yesterday, in response, you may be aware that ECAN issued a public notice this week announcing that a number of regulatory plans, including the Canterbury Land and Water Regional Plan and the Waimakariri River Regional Plan, have been amended to include 3 clauses, including one to avoid the loss of extent of natural inland wetlands. Yesterday, the Commissioners asked ECAN to describe what a natural wetland is, and they intend to reply in writing, and that explanation will be available to the public.
I was present yesterday when you asked that question of Council, and so I'm aware of that. I'm also aware that it has been a somewhat contentious issue through my work. I'm aware it's a contentious issue, but I am hopeful that the definition that is in the National Policy Statement and any clarification that goes around it will clear up that matter.
Hopefully it does too. Thank you. That's all from me.
Mr. Van Dorsen?
Yeah, thank you. Have you got policy 4.31 in front of you?
Of
The Land and Water Regional Plan, which I think it deals with livestock exclusion from water bodies, which is...
the amended one?
Yeah, the one from the 42A report, or the latest version of the amended provisions.
I'll just check I've got the same one.
Yeah.
I am.
So the issue of the conflict or otherwise and duplication or otherwise between the new regulations and the plan provisions is something that we're alive to as a panel, and we've asked a number of questions about that, and we're going to get some further information from that as the hearing proceeds. But when I look at 4.31, it seems to me that B, BA, BB and C are kind of unique to Canterbury in terms of the issues, well not Canterbury, but unique in terms of the issues they raise, and those issues aren't covered in the stock water regulations, which are more generic in their application to the rest of the country. But when I look at A, I see that as the potential area of most overlap. And just wanted to ask you a question, and I understand your concern relates to ephemeral streams, and of course under the Act they're rivers, because the Act talks about rivers, not streams. But and so in terms of that issue, if we were to amend A so that it would read, instead of rivers, it would say wide rivers, and then in brackets as defined in the RM Stock Exclusion Regulations 2020, because the regulations apply to wide rivers, which are defined as being rivers more than 1 metre wide. And of course, if that wording change was made, that would exclude ephemeral rivers, because they're not more than 1 metre wide all the time. Would that go any way to addressing your concern if we were to align that with the regulations definition?
Certainly in line of policy 4.31, yes it would. However, you do also need to consider policies 8.4.30 and 8.4.31, where they relate specifically to the Waimakariri sub-region and bring in permanently and intermittently flowing springs and open drains and other artificial watercourses with surface water in them that discharge into a lake, river or wetland. And then within the Ashley Waimakariri Plains area, which goes up to the 350 metre contour, they are a prohibited activity to have farmed cattle, deer or pigs present in any of those waterways. So the issue there is that that within the Waimakariri sub-region and the Ashley Waimakariri Plains area, we have brought into play through the policies water bodies that are exempt under the stock exclusion regs. Ultimately, when a reconsideration is done of the plans in light of the new MPS and Te Mana Utuai, once the local site-specific considerations have been taken into account, we could end up back with those back in. But my view at present is that the council have taken a blanket approach to all water bodies, and that it, to my mind, is somewhat conflicting with the established blanket approach that is now in the regulations, which at that higher level is giving effect to the national policy statement. So if you start with the regulations, you have as a starting base something that complies, in my view, with the national policy statement. And then if the council wishes to move to something more stringent, which may in certain circumstances be entirely reasonable, then it would need to do so in the context of Te Mana Utawai, and that more local consultation and ground truthing to actually make sure that the principles and that hierarchy of the obligations are actually being fully carried out.
It is a really long answer, so I've written down yes, but also need to look at zone-specific provisions.
Yeah,
Is that a fair summary?
that would be a very fair summary, yes.
Okay, great. No, thank you very much for that.
Well, could I just add a little bit to that discussion, because not only does it have to be in that context, but it also has to be in the context of Te Mana Utawai and the hierarchy of obligations. Is that a fair summary too?
Yes,
Ms.
it's,
Caseley?
that's a fair summary. I mean, Te Mana Utawai to me is putting the health and well-being of fresh water at the forefront of discussions and decisions. And in setting that hierarchy of the obligations, it's allowing for the resources to be directed towards freshwater management and to those issues on water bodies, particularly in the first instance, that are degraded. We know that there's not enough resources around to do everything at once, so we need to determine the priorities. And you start with using the regulations as a starting point, then allows you to come back and prioritise and then assess those specifics, which I believe is the right thing to do. And proposed plan change 7 was applying a broad brush approach, but I believe that their broad brush approach it doesn't align with that conforms with the regulations and the national policy statement. It goes beyond that without, to my view, without the correct information and assessment behind it.
Thank you. Further questions, Commissioner?
No, thank you.
Thank you.
Well, I think the discussion, Ms. Caseley, has dealt with the question I was going to ask about the item in your original submission. So what we can do is to thank you very much for the care and thoroughness with which you've prepared and for so willingly and helpfully answering the questions that we've asked of you. Thank you for coming.
That's right. Thank you for listening.
So, Ms. Fernando, do we have further business this afternoon?
No. We haven't had McFarlane turn up, and Aqualink are not attending because they're not well. The representative's unwell.
Yes, very well. Well, thank you. In that case, I'll adjourn the hearing until tomorrow morning at 10 o'clock.